Hello and welcome to today's webinar. It's going to be a really interesting session once again with Masin, covering pre-dispute conduct in construction projects and its benefits in dispute resolution in Qatar. My name is Joanna Lane, editor of Chambers Canada, Africa, the Caribbean, the Middle East, and offshore. And I am delighted to be joined by Masin CEO Rohit Singhal, Masin partner and country head for Qatar HK Suresha, senior partner of Sultan Al-Abdulla and Partners William Cattan, Pinsent Masin partner Pamela Mcdonald, and managing partner of DWF in Doha, Kirk, Durrant. The session today will last 45 minutes. If you'd like to join the conversation, we can accept questions via the text box on your screen or by emailing events@chambers.com. Should you have any technical issues at all, please click the question mark button at the bottom of the screen where you'll find some helpful tips. So moving on now to today's session, I will hand right over to Mr. Suresha, who will be moderating the panel today.
Thank you, Joanna. Good afternoon, all. We have three subtopics to discuss. The first topic for discussion is pre-dispute conduct during unlawful termination in construction contract. Now, questions to Pamela. The employer or contractors often use termination as a means to escape extension of time or cost claims. In such cases, how can termination be determined to be unlawful or lawful?
Thanks very much, Suresha, and thank you for having me today. So termination is something that's seen by civil code trained lawyers as a particularly nuclear option and one that parties really shouldn't take lightly. There's usually grounds for termination set out in the contract, and if there are, and if they are consistent with the mandatory principles of governing law, then a properly executed termination will be lawful in the sense that it was permissible and executed according to the contract for valid reasons and with adequate notices sent and so on. If there's no provision in the contract, and that's quite unusual, but if there isn't, then the grounds for termination in the relevant applicable law will apply. And in Qatar, where I am, there's grounds to terminate both for default and for convenience in the civil code if the circumstances exist. Now, in certain Middle East countries like Qatar, unless there are express words in the contract stating a court order is not required to terminate, then the court's permission should be sought pursuant to Articles 183 and 184 of the Civil Code. Now, in practice, that doesn't often happen because getting the court's permission essentially involves preparing fully substantiated, substantive pleadings to persuade the court of the right to terminate. If that court order isn't sought, though, the terminated party has grounds to challenge the termination as being unlawful for lack of court authority. So that's a really important point to bear in mind. Even in those circumstances, though, and returning to your question, Suresha, a party that owes another party money won't get out of paying because it's terminated. Because it terminated another party, rather. That's actually a terrible way of escaping cost claims, in my opinion. In fact, it's possibly going to lead to more liability if there are valid outstanding debts, and instead of paying, the other party terminated. That's only a good strategy if you're certain the party you're terminating isn't going to sue, which can never really be guaranteed, especially in this world that we're living in of third-party funded claims. The rights don't expire after a termination either, so contracts tend to contain survival provisions, which say even once the contract is terminated, certain rights and obligations are continuing. And as a matter of law, a statutory limitation period of 10 years exists for merchant contracts, like construction contracts, regardless of when the project ended or if it was terminated. So the right to pursue those claims doesn't go away because of the termination. The last thing I'll say is notions of good faith are particularly relevant in these scenarios, again, because of the severity of the act of a termination and the reputational damage and business disruption it gives rise to. And terminating without good reason and without having proper attempts to resolve the claims will be perceived negatively in that context. Thank you.
Thank you, Pamela. So now a question to Kirk. How do parties find themselves in the situation where they are in middle of executing works and suddenly their contract has been terminated? How must parties react to such an event?
Kirk, I think you are on mute.
Yes, I was on mute. Phrase of the day. Thanks for the question. I think there are two questions there, and thanks for having me, Suresha. So just to sort of give a little bit of context, as Pamela indicated, this termination, especially in the middle of a contract, is usually a nuclear option. It's usually the option of last resort. And how do parties generally find themselves in this situation? In my experience, 9 out of 10 times, this option is deployed when the cash flow position on a particular project is impacted in such a way that the contractor is unable or unwilling to fund completion, either wholly or partially, without financial intervention by the employer, generally significant financial intervention by the employer. This usually happens because of a combination of reasons. Key among those reasons are the following. One, when there are either poor contract terms on the issue of resolving disputes, or poor administration of the contract terms relating to the resolution of disputes. And what that usually results in is that disputes sort of persist without resolution for a long time, causing a domino effect on the progress of the project, which ultimately stifles cash flow and results in termination. Now, there are certain things that contractors should do to minimize this. And there's a saying in my line of business that says that the time to fix the hole in the roof is when the sun is shining. And what that usually means is what you want to do is, before you enter into contracts, you want to make sure that your contracts have good dispute resolution provisions in it. And when I say dispute resolution, I don't mean sort of formal dispute resolution, but at least mechanisms that allow you to quickly and efficiently resolve differences that arise during the construction of the project. If your contract has sort of good mechanisms, clear mechanisms for addressing issues that come up on projects, then that's sort of a step in the right direction. The second part of that, obviously, is administering those provisions such that you get expedient and efficient resolution when issues arise. Now, in response to the second part of the question, what should parties do when they find themselves in this situation? Well, there are two things you want to do almost immediately. And one of those things and both of those things actually, I'd suggest you do these as early as possible. And if you can, even prior to actual termination, even prior to an actual termination notice. The first of those is I'd suggest you hire a lawyer. And as self-serving as that might sound, I don't intend it to be. The reason why I suggest that that's sort of one of the first things you want to do is because you're likely going to encounter a lot of legal issues that really do need to be administered properly to avoid the lawful versus unlawful termination question. So that's the first thing to do. The second thing you want to do is protect your bond position. So most often there'll be a performance bond, there'll be an advance payment bond, maybe a retention bond, whatever bonds you have in place. One of the first things you want to do is protect your bond position, because almost inevitably when there's a termination, there is almost always a liquidation of the bond. So you want to protect your bonds. There are a number of ways to do that. especially in Qatar. A lot of times it depends on the language on the face of the bond. There are central bank regulations that you might be able to resort to for some protection of the bond. There are Qatar civil law provisions that you might be able to rely on for protection of the bond. So you hire a lawyer. The lawyer should be able to guide you with respect to what you need to do to protect that bond. The second thing you want to do almost immediately is agree on an early and orderly handover of the project. There is usually this inclination to stall and make things difficult for the terminating party, and I suggest that that's not a good approach. Because by doing that, you're simply making the consequence of termination worse. You're generally delaying sort of a completion contractor coming on, which means you're dealing with spoliation issues. You're dealing with the completion contractor incurring increased costs, which potentially increases the terminated contractor's exposure. So you want to agree an early and orderly termination with reports, with photos, with videos to preserve the position going forward. And the last thing you want to do is you want to make sure your documentation is in order. You'll need them. As Pamela alluded to, litigation is an almost certainty when you have termination, and so you want to make sure your documentation is in order. Thank you.
Thank you, Kirk. Now, question to William. One of the common issues faced by contractor and subcontractor during an event of unlawful termination is the encashment of a bank guarantee. What remedies and claims are available for parties under Qatari law?
Thank you. Thank you very much. Not wanting to contradict my friend and colleague Kirk, I think the short answer is that there are very few options. Excuse me. Going back 6 or 8 years ago, you could go before the Qatar courts and have a 50-50 chance the judge would enjoin the issuing bank from honoring a withdrawal request. Today, that is very unlikely. You can still make a request to the court, and the petition will be heard ex parte, meaning without the knowledge or participation of the employer. But the petition is likely to be denied, and there are several reasons for that. First, the contract terms are likely to be against the contractor. Bank guarantees are generally drafted as unqualified, unconditional, pay-on-demand instruments. And secondly, the law is also against the contractor. Qatar law basically states that a bank cannot refuse payment of a guarantee because of any issue between the bank and the contractor who arranged the guarantee, or any issue between the contractor and the employer who's the beneficiary of the guarantee. There's also a practical issue a contractor faces, even if he has a very strong factual basis for contesting the encashment of a guarantee. I will give you an example of a strong factual situation. We had a client, a contractor, who was offered a very low amount to settle a dispute. So the employer acknowledged the contractor was owed money and had made a settlement offer. It was a lowball offer, and the employer tried to pressure the contractor into accepting the offer by threatening to encash the performance guarantee. When the contractor refused the offer, the employer did, in fact, encash the guarantee. That was clearly a wrongful draw because the employer was not entitled to any payment from the contractor at that point. The practical issue I mentioned arises from the fact that under Qatar procedural law for the Qatar courts, even if an injunction is issued by the interim matters court, the contractor is required to initiate a substantive suit on the merits within 10 days or the injunction will be lifted. And it's very unlikely in practice that the contractor is going to be prepared to initiate a lawsuit within that short period of time after an injunction being issued. Now, the situation may be different if arbitration has been designated in the supervisory court, which in Qatar arbitrations or arbitrations seated in Qatar, could be the Qatar Financial Center Court, if that court is willing and able to move quickly. Qatar's arbitration law provides that unless the parties agreed otherwise, an arbitral tribunal can take temporary measures or issue an award for purposes of avoiding an otherwise irreparable damage. And we have been successful in obtaining such an order in an ICC arbitral proceeding. But in many cases, the tribunal will not have been impaneled at the time the risk arises of an employer encashing a guarantee. Ultimately, The contractor's remedy, unfortunately, is to go through the process of initiating a claim against the employer for the damages arising from the wrongful encashment of a guarantee. Thank you.
Thank you, William. Now, questions to Rohit. What care should a party take while setting out a claim during unlawful termination?
Thank you, Suresha. As we have already understood, from the last three speakers, that how difficult is to deal with unlawful termination. Now, first and foremost, which a party or a contractor which is going to probably claim the money for unlawful termination, what the contractor has to ensure is that whatever work has been done, preferably there should be a joint record of the work. So as soon as there is a termination notice, there should be a notice be sent to the employer or the engineer to see that there is a joint record of what is the total extent of work which has been undertaken, either fully, completely, or partially, because at the end of the day, how it is going to be valued is based on such a kind of a joint record. Number one. Number two, there would be some materials which would already be there in the warehouse or at the site of the contractor, and probably there will be some material which will be there in the warehouse of the subcontractors and all. So all those materials against a joint record which is signed by the contractor and the engineer or the employer is also maintained and should be signed off. Then the other thing is, once all this is done, the number of resources which were there at site at the time of termination, a joint record, if it is there, that is also preferable. Same way, number of manpower, number of equipment, and everything, a joint record should be there. Now, once all this is done, basically the law, the Qatari law says that whatever is the actual loss which has been suffered by the contractor owing to the so-called unlawful termination has to be claimed. And on top of it, depending upon the provisions of the contract or law, at times a loss of profit claim can also be put in. But of course, subject to legal provisions, it's a difficult claim to get through, but I'll not get into that. So the first and foremost thing which a contractor has to ensure is a joint record of whatever his losses and expenses related to work done, partially or fully, material, as well as resources should be there. And then, of course, as part of the termination, there could be some termination costs from the vendors or suppliers. So again, those details, those notices from those respective vendors should also be there, so that all this can be consolidated to submit a proper substantiated claim to the employer and engineer. And if it goes to arbitration, there are sufficient evidences to prove the claims and the losses. Thank you, Suresha.
Thank you. Now we move on to the next subtopic, pre-dispute conduct during completion of construction contracts. A question again to Rohit. What is substantial completion and contractual completion? How does this matter in delay analysis?
Yeah, so Suresha, very nice question. This is something which is, generally confused by a lot of people. There are two, completion is, everybody thinks completion is completion. No, completion legally and contractually has got different, meanings to it. Contractual completion is what is defined as the definition of completion in the contract. Many a times it is said that everything has been finished, all works have been finished, from the last nut and bolt all the way it has been done, final as-built documentation, final documentation have been handed over. So that is defined at times in majority of the circumstances as overall completion or contractual completion. Though in certain contracts, it is clearly stated that minor activities which are pending, which do not affect the intent or the objective of the project, can be excluded from the term completion. But again, contractual completion means what is defined in the contract. Vis-a-vis substantial completion means that majority of the work is finished, the project has met or is ready to meet its objective. For example, gassing can be done, or whatever is required in an oil and gas project or a power project can all be finished. And what remains are minor works, punch list works, which probably do not affect the commerciality of the project or operation of the project. So therefore, many a times contractors put in their request for issuance of the completion certificate, saying that since majority of the work is done, substantial completion is done, I should be issued a completion certificate, even though some minor works like snag points, etc. are pending, which can probably be done during the defect liability period. So Now, to answer your second question in terms of delay analysis, as a delay expert, when we are getting into an arbitration and we act as experts, we need to see what is the pleaded case. If the pleaded case of the claimant is that that substantial completion is achieved, and what remains as minor snag points, and they do not affect the intent or the objective of the project, then maybe we will do a delay analysis to show the completion towards the substantial completion, to consider completion as the substantial completion. But then definitely we also have to give an alternate to the arbitrators that if they reject the position of the claimant and go for a complete completion, the contractually defined completion, then we may also have to do a delay analysis and alternate position towards the overall completion or the contractually defined completion. Thank you, Suresha.
Thank you. I have another follow-up question on the same subtopic. How must party conduct itself after substantial completion of the project?
Yeah, so again, what I have experienced is that, a large number of contractors become very relaxed once they have achieved substantial completion. And recently we were in an arbitration where the issue was only pertaining to the time between the substantial completion and overall completion. So a substantial completion was achieved, but the overall contractual completion was delayed because a contractor became relaxed during that phase between the substantial completion and contractual completion, and those minor snag points or those whatever balance final documentation, etc., were not submitted on time. And therefore, the employer or the respondent argued that since the definition of completion and the LD is associated with the overall completion or contractual completion, therefore there is a delay. So what a contractor should ensure is, number one, that snag points which are minor in nature still have to be completed. So a full focus should be there on completion of those. Final as-built documentation, final handover documentation, all that should be there, done properly and in an expeditious manner. They should not get relaxed. And then at times what we have seen is that the progress reports, the monthly, weekly, daily progress report are not submitted once substantial completion is achieved. They should also be submitted. In case the progress reports do not have that provision in the programs, the schedules, to indicate the work between substantial completion to contractual completion, but then a list, an Excel sheet of snag points, what are there, and all that should be specified and should be identified as part of the progress report and should be submitted. Same way, whatever are the resources which are deployed during this time phase should also be accounted for and should also be recorded. Thank you, Suresha.
Thank you, Rohit. Now, questions to William. What legal or contractual provision does a party need to rely on to define the substantial completion and the contractual completion?
Well, what the parties have agreed to as a matter of contract is, of course, a key issue. There are multiple forms of contracts in use in the Qatar market, some of which utilize FIDIC forms and some of which do not. Under some contracts, and depending on the nature of the facility being constructed, the issues may be more complex than just the difference between substantial completion and contractual completion. For example, I was involved in a dispute in which the EPC contract at issue specified 5 levels of approval and acceptance by the employer. Under FIDIC terms, when a contractor determines that works are ready to be handed over to the employer, the contractor applies for a taking over certificate, and that certificate should be issued by the employer or the engineer if the works were completed in accordance with the contract, except for any minor outstanding work and defects that will not substantially affect the safe use of the works for their intended purpose. And Qatar law basically leads to the same result under the Civil Code. If a defect in construction does not render the works unfit for their intended purpose, an employer cannot reject the works but can require the defect to be fixed or the contract price to be reduced. Since contractual terms vary, I'd like to make a couple of observations based on my personal experience that I think are relevant to the issue. The first is that when the reaching of a milestone like substantial completion is in dispute, it is frequently a very complex, technical, and fact-specific analysis. With respect to contracts that provide for an engineer to make determinations, there is almost always a dispute regarding a required determination or certification that the engineer has refused to issue. In Qatar, this may arise because many government employers have moved the engineer's function in-house, meaning that the employer appoints one of its own officials as the engineer, effectively eliminating the distinction between the employer and the engineer. There are provisions in Qatar law, in addition, that relate to completion that can be very difficult for contractors, irrespective of their contract terms. And I will give you 3 examples. The first is that Qatar law sets a very high standard with respect to fitness for purpose. The Civil Code says the contractor must provide, at his expense, whatever manpower and tools and tasks he shall need in completing the work unless the agreement or custom provides otherwise. And a respected commentator on that provision of the law has written that in respect of construction of a building, the contractor cannot be relieved from this obligation until and unless the intended purpose is achieved. It is not sufficient to exert efforts or to exercise the normal duty of care of an ordinary person, or even the maximum duty of care, as long as the work has not been completed. And that interpretation could turn fitness of purpose into something closer to an operational guarantee. Second example of applicable law. There is no definition of handover in the Civil Code. And if the contract is not clear on the point, there is a question under Qatar law whether handing over requires the approval of the employer. The same commentator that I quoted from previously has written that handing over is not merely making the works accessible to the employer, but encompasses the employer's acceptance of the works. That writer went on to state that handover should be the final, not preliminary handover, and if there is a gap in time between physical delivery and acceptance, for example, for purposes of testing a facility, that handing over takes place at the time of acceptance. The third example is that contractors in Qatar are subject to decennial liability, meaning that liability for 10 years exists for the full or partial collapse of the building, irrespective of substantial completion, contractual completion, or any other form of completion. On multiple occasions in my practice, contractors have signed contracts governed by Qatar law without proper legal review, and it is a very unhappy revelation when they learn about decennial liability that extends well beyond contractual completion. After that kind of string of bad news for contractors, my final practical observation is a bit of good news, I hope, for contractors. And that is that in my experience and the experience of my firm, irrespective as to whether required certificates have been issued, and also irrespective of the topic that I'll address in my final comments, which is notice requirements, whether those have been complied with. The Qatar courts tend to award contractors compensation when works have been delivered to an employer and the employer has commenced using and benefiting from those works. Thank you.
Thank you, William. Now, question to Pamela. What does the discrepancy between the substantial completion and contractual completion have on the imposition of liquid damages under the contracts?
Thanks, Suresha. It's a really common scenario that a contractor will say, on the one hand, it's completed, and the employer will take the view that not all of the contractual requirements have been met for completion. So just to take a step back and remember why that's important, contractually, completion will usually trigger various things. It starts the DLP, it starts warranty periods running, different insurance policies might kick in. It might mean that the first half of retention is released. It might have an impact on the release of certain payment guarantees and bonds. But probably the most significant consequence of completion is it's the date on which LDs start to accrue if it's missed. So in a scenario where relationships have broken down and parties are polarized, the contractors are keen to suggest completion has happened to avoid LDs, and employers point out all of the reasons why it hasn't to levy LDs. And whether it has or hasn't needs, as Will has just said, needs an analysis of the contract to understand what needs to be done in order to say completion has happened. But often the contract isn't as prescriptive as it could be. And so in creeps these notions of substantial and practical completion. In other words, completion of almost everything, bar some snagging. For example, the asset might have been taken over by an O&M contractor, or the employer has started making use of it, for example, in Qatar to hold, let's say, test football matches in a stadium, for example. So substantial completion can be said to be a state of affairs in which the works have been completed free from patent defects, not latent, but patent defects, other than ones which are trifling. And whether or not an item is trifling is a matter of fact and degree, measured against the purpose of allowing an employer to take possession and use that asset as it was intended to be used. Although it's worth saying the fact that an employer can take possession and use it as intended doesn't always mean that it's practically complete. And another point to just make here is that the mere fact that a defect is irremediable doesn't mean that the works are not practically complete. And these sort of, issues that we're talking about, they come up very regularly because LDs are often, say, 10% of the contract price. So it's a lot to fight for. It can be the profit margin, obviously, of a project. And a tribunal or a judge analysing when completion happened and when LDs start to run from, if there isn't a valid EOT, will need to be persuaded that the balance of outstanding works on the date completion happened was merely trifling. And that means parties have to forensically analyse the contract and what was required of the contractor, including by reference to the contract specifications and provisions, especially usually around testing and commissioning.
Okay, thank you, Pamela. Now, question to Kirk. What issues do parties face in making arbitration document due to discrepancy between the substantial completion and contractual completion?
Thanks, Suresha. So as I think all the speakers have already suggested, whether there is a discrepancy between substantial completion and contractual completion depends heavily on the terms in the language in your contract. If your contract obviously addresses these terms independently, then the analysis of the legal position as against each requirement simply becomes a matter of interpreting the contract. If the distinction, however, is not addressed in your contract, then what you effectively have is arguing a non-contractual equitable milestone, which is substantial completion, against what is generally a pretty express milestone, which is contractual completion. When you are in that scenario, it is usually difficult because, and I think it's Rohit that alluded to this, all your documentation that you put together will be generally designed to support an equitable position. And you, on the other side, what you'll be faced with is documentation obviously supporting a contractual position. That's never an enviable position to be in. Nevertheless, that's what you have to do. Obviously, assemble the documentation that supports this position. In Qatar, in particular, there are a number of Qatar civil law provisions that a contractor might be able to rely on to support an equitable position, and obviously the documentation to support those positions. A word of advice, though, if you do find yourself in a position where you're arguing for this equitable position, it's wise to argue in the alternative. What I mean by that is to argue that, look, here's the documentation, here's the argument supporting substantial completion, and we say that substantial completion was met at this particular time. But if the tribunal or the court is inclined not to accept this position, here is our analysis and documentation supporting when actual completion occurred, with a view towards minimizing the exposure.
Thank you, Kirk. Now we move on to the last and third subtopic, that is benefits of crystallizing and updating claims prior to formal dispute resolution. Now, question to Pamela. Could you please briefly explain the treatment of delays, concurrent delays, and time-related costs under Qatari law?
I think, Pamela, we are not able to hear you. Suresha, we can move to the next question, and once Pamela joins, we can.
Yeah, of course. Now, question to Rohit. What are the benefits of updating previous claims while triggering the dispute?
Yeah, so Suresha, what happens is, in construction contract, typical construction contract, the dispute resolution mechanism is a phased-wise dispute resolution mechanism, wherein a contractor or any party cannot directly jump into arbitration generally. So they will have to go through the steps which are identified in the dispute resolution clause. Now, what happens, supposedly if a contractor has submitted an extension of time and a prolongation claim and some variation claim, maybe 6 months before the start of the dispute, it is always, recommended and also at times contractually required that the claims are updated just before the start of the dispute process or dispute or arbitration process. It's for various reasons. Number one, getting an updated claim, you get to understand what is the extent and value of the claim. Engaging an external expert to identify what are the strengths and weaknesses of the claims also helps the claimant who's bringing up the claims. And at times, supposedly, if there was an extension of time claim prepared 6 months before, and before the start of arbitration, you don't update it, it could be possible that some of the delay events which have taken place in the last 6 months before the previous EOT submission and just prior to the start of the arbitration might not be covered in that and might not have gone through that dispute resolution mechanism process which is defined in the contract. But then, of course, updating of the claims also has importance when it is an institutional arbitration, because then you get to know what is the exact fee of the institution, like ICC, DIAC, KICA and all, which the institution is going to charge. And at times, claimant might have to take a decision that if a claim he thinks is not meritorious and should not be raised, then he would probably end up saving some money from the from the fee which the claimant or the contractor is going to pay to the institution. So in my view, updating the claims just prior to the start of the arbitration or dispute and getting an independent legal and contractual and expert opinion is mandatory. It helps the contractors a lot. Thank you.
Thanks, Rohit. So I think Pamela is back, and we'll move on to the previous question. Question to Pamela. So could you please briefly explain the treatment of delays, concurrent delays, and time-related costs under Qatari law?
Certainly. Thanks, Suresha. So most construction contracts will contain provisions governing the time for completion and perhaps even sectional completion for certain milestones. There's also usually a penalty for not achieving that date in the form of liquidated damages. Since it's usually in the contract, you often don't usually have to look at the civil code to understand what the position is and the risk allocation under the contract. But if it's absent from the contract, there are certain articles in the civil code which are relevant and helpful in moments like this. So one of them is Article 687 of the Qatar Civil Code, and that contains a provision in respect of the time for completion. And I'll just read it out, it's quite brief. It says, the contractor shall perform the work in accordance with the conditions as set out in the contracting agreement and within such period as agreed. Where no such conditions are set out or no such period is agreed, the contractor shall perform the work in accordance with the applicable practices and within such reasonable period as required for the nature of the work, subject to established standards of workmanship. So where a construction contract doesn't include a time for completion, or for some reason the mechanism for extending the time for completion has broken down, bad administration of the contract by the employer, for example, the Qatar Civil Code will or could be used to impose an obligation to complete the work within what is a reasonable period, taking into account the nature of the work. That sounds a lot like time at large principles emanating from common law countries like England and Wales, where if the mechanism for extending time has broken down, then the contractor has to complete within a reasonable time. It's the same kind of idea. And in that context, notions of imposition of liquidated damages in circumstances where the contractual mechanism is broken, it is arguably in contravention of good faith. That's also generally how these types of things are pleaded. There's no specific provision in the Civil Code relating to extending the time for completion, but there's a number of articles which operate to modify the parties' rights and obligations in respect of a failure to complete work on time. Liquidated damages are permissible by Article 265, and they're capable of being adjusted as well by 266 in certain circumstances. But the wording of 266 does need to be read very carefully, both sentences, and parties thinking of relying on that clause need to just be alive to the fact that it's really difficult to prove a lesser amount of loss than the amount stated in the contract, the LDs in the contract. A lesser amount has been incurred, and the burden is on the party alleging it to prove it. So unless you have access to financial accounting information, which in the Middle East is not generally publicly available, those are quite difficult claims to assert. In relation to concurrency, Article 257 of the Code provides that the compensation can be reduced or not awarded at all if a party, through its own fault, contributed to or increased the loss. That's usually taken to mean that a apportionment type approach is adopted to concurrency in Qatar. And usually in a claim scenario, the contractor won't include concurrency, at least in the first claim, and will insist that the employer has to show it if they're alleging concurrency exists. Before you get into that, though, there's often exchanges regarding what is meant by concurrency, since the contract doesn't always express it clearly, if at all, and it can obviously have different meanings depending on what definition you use. But usually it comes down to that forensic analysis of the programs, which is really needed to make a fair assessment. Final point, other than liquidated damages, a contractor's time-related losses are often not expressly said to be recoverable in the contract, but they are recoverable as a matter of Qatar law under Article 263 if they arise from events which constitute a breach of contract. And that's typically how a contractor seeks to recover its prolongation costs, unless the event giving rise to the delay is a variation, in which case typically you would get time and money as a matter of contract. If it's an Article 263 claim, the party seeking compensation needs to show it was a natural result of the breach, and the compensation includes, or that's available includes actual loss and profit. Thanks.
Thank you, Pamela. A question to Kirk. How should a party crystallize the dispute, and when must any party invoke the dispute resolution clause with reference to earlier discussed topics?
Thanks, Suresha. So a couple of things. I'll answer those questions in reverse order, and I see that we're running out of time, so I'll try to be brief. So as to how to trigger the dispute resolution clause, well, it depends on the terms in your contract. To determine if a dispute has arisen, obviously, unless your contract says otherwise, it is at the time when both sides express a differing position on a particular issue. So if both sides say something different about a particular issue, safe to assume that a dispute has arisen. how do you crystallize the disputes? As soon as it becomes apparent that a dispute has arisen, the thing you want to keep in mind is that the administration of the dispute resolution provisions in your contract must be adhered to the letter. You really want to be careful that you're adhering to what's required to the letter. In most cases, that process is triggered by some sort of notice, and it's critical to make sure that you comply with both timing and content requirements with respect to that notice. Again, I'd suggest that if you find yourself in this situation, seek outside help. Oftentimes, parties that are involved in a project or close to the project are generally emotionally tied to the issues and lose sight of sort of the goal ahead, which is to make sure the administration of this process is to the letter. Thank you.
Thanks, Kirk. The last question on this webinar is the question to William. What legal and contractual step must be taken to solidify the claim and trigger the dispute, and what conduct must it display before or during issuance of notice of dispute?
Thank you very much. I noticed a question to me, but I don't think we're supposed to answer them right now. We have to answer them later if there's time. So in response to this question, of course, any sophisticated contract will set out a dispute resolution mechanism, which could include various steps that parties are required to take before going into, for example, formal arbitration or formal litigation. And it is important to comply with those required steps. Failure to comply could affect the admissibility of a case before an arbitral tribunal. Now, in Qatar, the Qatar courts are less concerned about what has or has not happened before a case is initiated. But in practice, parties that are considering initiating formal dispute resolution proceedings normally take time to consider that decision. And so there's really no reason not to comply with whatever steps are set out in the contract. And as a result, in my experience, these requirements are not often problematic. In contrast, notice provisions, which a contractor, for example, is required to give notice to an employer of events that have cost or timing implications, and then restrictions on the contractor's right as a result of failure to comply with those notice requirements. These types of provisions are often a big problem for contractors. Notice provisions can be burdensome in terms of the form of notice and the factual analysis and supporting documentation that is required. Often they are also ambiguous. So this is an actual contractual provision. It says the contractor shall give notice to the engineer of a claim as soon as practicable, whatever that means, and in any case within 7 days after the contractor became aware or should have become aware. Again, how do you measure that? Of the event or circumstance, failing which the contractor is not entitled to any additional payment or time for compensation. One of my clients told me that in order to fully comply with the notice requirements in one of his contracts, he would have needed to constitute a dedicated team that did nothing all day but crank out notices of dispute. So what does Qatar law say on these issues? Notice and time bar provisions are generally enforceable under Qatar law, and accordingly they are very dangerous to contractors. So Qatar law will respect and enforce a clause like the one I just read. But on the other hand, Qatar law does recognize the concepts of actual or constructive notice. In my experience, it is extremely uncommon in construction disputes in Qatar or elsewhere that both sides are not, in fact, actually aware of the events giving rise to the claim, irrespective as to whether formal notice has been given in accordance with the contract. Under Qatar law, a formal, contractually compliant notice is not required where the party to be notified has actual constructive notice of the relevant facts giving rise to the contractor's claim. So an argument that actual or constructive notice has been provided can be made, is often made, and typically is supported by a fact and documentation intensive analysis of emails, letters, and other communications between the parties. In addition, in my experience, it is often the case that the employer or the engineer also did not comply with contractually mandated procedures applicable to them. For example, the employer might not have responded in a timely fashion to notices it received from the contractor. And in Qatar litigations, at least, the courts have been very receptive to the argument that it is unfair to hold one party to a standard of performance not observed by the other. Finally, under Article 91.1 of the Civil Code, parties can evidence or amend a contract through course of conduct. If the employer did not raise time bar concerns at the time a contractor asserted its claims, the employer, for example, if the employer responded to the substance of the contractor's claims without regard to whether notice had been properly or timely given, then a court or arbitral tribunal could conclude under Qatar law, by course of conduct, the parties had amended the contract to remove the notice and time bar provisions. Just one clarification before I close. I've been discussing a provision that says if you don't give a required notice, you lose your entitlement to compensation or an extension of time. In contrast, a contractual provision that says if you don't give a required notice, you lose the right to make a claim, that provision is unenforceable under Qatar law because it has the effect of reducing the statutory time period for asserting claims. It may sound like a subtle difference, but the point is that contractual limitations cannot prohibit a contractor from going to court or to an arbitral tribunal. Once there, a contractor who has not complied with the notice provisions can try to rely on the arguments I've just described, for example, that the employer had actual or constructive notice and contractually compliant notification, therefore, was not required. Thank you.
Thank you, William. Now I will hand over back to Joanna for her final note.
Thank you, Suresha. Unfortunately, that's all we have time for today. So many thanks to Masin for today's insights, and to you, our audience, for logging in to today's session and for submitting your questions. We did have a lot of questions today that we haven't managed to get to. If you do have any follow-up questions that weren't answered or that you didn't get to ask, please do get in touch with Masin directly using the contact box on your screen. So have a great rest of your day. Thank you again for joining, and I hope to speak with you again soon. Goodbye.
Thank you.
Thank you, Joanna.
Thank you.
Thanks, everyone.
Thank you.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.